This is part 3 of episode 1, and the links to the parts 1 and 2 will be found in the description below. Now, this is some information one needs to know to fully comprehend further arguments. There are two types of powers of the parliament. The first one is lawmaking power, which is called legislative power, and the second one is constitution amending powers, which is called the constituent power. This is one of my favorite arguments. So here the petitioner argued that while passing legislative bills, the constitution granted powers to both Lok Sabha and Rajya Sabha to make changes to the bill after debating and discussing in the House. In case the Lok Sabha or Rajya Sabha didn't reach any consensus on the changes to the bill, a joint sitting would be called by the president and then they'll take a vote, and whichever change gets over 50% of the vote will be retained and will be passed as a law after president's assent. But in case of an amendment to the constitution, it must be passed without any changes after it was presented in either Lok Sabha or Rajya Sabha. This is because Article 368 is a full and complete code about a constitution amendment, and in this full code, there's no mention of changing any provisions of an amendment bill after presenting it in the parliament. So, there's no such mention here because in case of an ordinary bill, Lok Sabha and Rajya Sabha can make changes to a bill, and if there's a deadlock, they can resolve it through joint sitting, and all of this is clearly mentioned in Article 108. Now, if we allow Lok Sabha and Rajya Sabha to change a few provisions of an amendment bill after presenting it, and if neither of the house agrees to changes made by the other house, there's no way out of this deadlock. And if we allow either house to make any change, the entire constitution machinery would break down and no amendment to the constitution can be passed. And because Article 368 is a full and complete code, if there were to be a way to get out of a deadlock, it would clearly be stated in Article 368, and there's nothing about a deadlock in Article 368. So, the only way to avoid this deadlock is to nip it in the bud and not allow any change in the first place so that the constitution machinery would function smoothly. So, Article 368 implicitly says that no house can change any provision of a constitution amendment bill once it is presented in the house, and all these bodies can do is either assent it or reject it. Now, since the actual parliament didn't even have these powers, the provisional parliament can be the recipient of these powers through Article 379, and it shouldn't have amended the bill after it was presented in the House, and for this reason, this amendment is invalid. To this, the state said that this argument has no merit because Article 107 and 108 clearly talk about amending the bills in both the chambers, and the constitution bills are to be dealt in the same manner. So, amendments to any bill must be allowed without any precondition. On this aspect, the Supreme Court held that Article 368 first isn't a comprehensive code, and there are a few obvious gaps on procedure in Article 368. And keeping these gaps in mind, Article 118 empowers the Parliament to make its own rules for conduct of business, and this includes a procedure in case of a deadlock to a constitution amendment bill. The petitioners also argued that since the amendment takes away our fundamental rights and Article 13 clearly forbids the state from enacting any law that violates our fundamental rights, this amendment is invalid. Again, this is because law also includes constitutional law, so an amendment to the constitution means an amendment to a law. Recognizing the sanctity of fundamental rights and constitution in general, the framers wanted to protect the constitution from amendments according to the whims and ideologies of the parties in power. For this reason, the framers put a few obstacles in place after perusing constitutions of major democratic countries. And since the fundamental rights chapter was inspired by the American Constitution, and American Constitution prohibits the US Congress from amending the fundamental rights, it is obvious that our constitution prohibits the parliament from amending the fundamental rights. So, the essence of Article 368 was completely obliterated when this provisional parliament, a single body, amended the constitution. So, for this reason, this amendment should be declared unconstitutional and invalid. The petitioners also argued that by virtue of Article 379, the provisional parliament has certain powers, and attached to these powers are responsibilities and duties. These duties are obvious from the phrase perform all the duties of the parliament in Article 379. In this case, it is a duty of the provisional parliament to protect the fundamental rights. So, if anything, this provisional parliament should protect our fundamental rights and not to do the opposite, that is, encroaching our fundamental rights. And since this provisional parliament did encroach on our fundamental rights, this amendment is unconstitutional. The state countered to this argument by saying the use of phrase perform all duties of parliament in Article 379 does not in any manner cut down the power of the provisional parliament because Article 13 does not impose any duty on the parliament. And also there's no conflict between exercising powers of parliament under Article 379 and the prohibition in Article 13. That's it. This was the state's argument. On this issue too, the Supreme Court rejected the arguments of the petitioners and held that different constitutions have different methods of amendment. For example, a few conduct a referendum, another few by a special convention, and another by legislation under special procedure. So it goes on and on. Now, just looking at our own constitution, it clearly tells us which method our framers chose. That too after considering all democratic constitutions. So these things cannot be compared to similar provisions in other constitutions. We have our own method. On the other issue, the Supreme Court rejected the arguments of the petitioners and held that we agree that constitution gave fundamental rights a lot of value and sanctity because it has put special difficulties in place to amend the fundamental rights. Now, normally law also includes constitutional law and there's a clear distinction between legislative power and constituent power. The legislative power is primarily concerned with the executive branch. So, a law as defined in Article 13 will only come into play if it's a law that deals with making laws for the executive, legislature, and judiciary. And the word law here means just rules and regulations because the framers used the word law in Article 13 to protect invasions of rights by the executive bodies, not from the sovereign constituent power to amend the constitution. Had they wanted to absolutely protect the fundamental rights as they were originally included, they would have simply added a provision excluding them from being amended in Article 368 itself. And since there were no such limitations in Article 368, the Parliament is deemed to have absolute power to amend the constitution. So the power of parliament to amend the constitution, the constituent power, has no limits. And Article 13 and Article 368 must be construed harmoniously. So Article 13 doesn't come in the way while amending fundamental rights, and Article 13 doesn't come in the way of Article 368. Before going ahead, keep in mind that the original Article 368 didn't have the word parliament in it. It just had the phrase either house of the parliament. The current day Article 368 has the word parliament along with the phrase constituent power, and also its title was amended from procedure for amendment of the constitution to power of the parliament to amend the constitution and the procedure thereof. And all these changes were made through three whole amendments, but this is an issue for another episode. The other argument went on like this. The body that amends the constitution is one body, and the body that prepares laws is a different body. Article 368 was not intended to be used by the provisional parliament by the framers. So Article 379 just granted the legislative powers to the provisional parliament with which they can enact normal laws. Also, Parliament consists of three different entities: Lok Sabha, Rajya Sabha, and the President. So, it's plain and obvious that Lok Sabha is a different body, Rajya Sabha is a different body, and the office of the President is another body. All these three independent entities are collectively referred to as the Parliament. So, it is implied that Lok Sabha, Rajya Sabha, and President are completely independent and separate functioning bodies. Now, Article 368 says that a bill can only be presented either in Lok Sabha or Rajya Sabha, and after getting requisite approval from both the houses, it requires the assent of the President to come into force. While passing bills on amendment to the constitution, Lok Sabha and Rajya Sabha are considered as separate and independent entities and not as a part of the parliament. This separate and independent body consists of 2/3 of the members of Lok Sabha and 2/3 of members of Rajya Sabha, and then the president, as opposed to parliament, which consists of all the members of Lok Sabha and Rajya Sabha and president. So essentially this new body is different from the parliament, and the only common connection of these two bodies is that all the candidates of these two bodies happen to be members of the parliament. For the sake of a convenience, let's call this body amending parliament. Amending parliament. So, the petitioners went on to argue that members of Lok Sabha, Rajya Sabha, and President wear different hats while performing different tasks. So, while framing laws, they're part of the parliament, and while amending the constitution, they're exercising their constituent power as members of this different body, which we call amending parliament. This distinction is clear when we look at Articles 2, 3, 20, 33 and 34. In these articles, the Constitution specifically used the word parliament while empowering the parliament to perform a few actions. So it means the Constitution knew that there were two different bodies. So they made that distinction by just using the word parliament whenever required and impliedly referred to amending parliament in Article 368. So that's why the word parliament is purposefully avoided in Article 368. And the phrases either House of the Parliament and 2/3 of the majority were explicitly used to make it clear that this amending parliament is different from the normal parliament. The petitioners went on to argue that now amending parliament is different from the actual parliament, and the parliament has no power to amend the constitution. Since the provisional parliament is a recipient of powers of the parliament, and since this parliament has no power to amend the constitution, the provisional parliament does not have the power to amend the constitution. So this amendment is not valid. So, the petitioners concluded by saying that since amending parliament is different from the actual parliament and Article 379 only granted the powers of the actual parliament, this amendment is unconstitutional because the provisional parliament is just the recipient of the powers of the actual parliament. And since this parliament itself has no powers to amend the constitution, the provisional parliament didn't inherit these powers. To these arguments, the state countered by arguing that the Parliament's power to make amendments in statutes flow from the same authority, that is, the Parliament. This reasoning can be informed from a reading of Articles 2, 3, and 4, which say that 2/3 of majority isn't required if any changes are made to Schedule 1 and Schedule 4, and any change to them shall not be considered as an amendment to the Constitution. These articles and corresponding schedules delineate the territories of state and the number of elected representatives prescribed per state and similar details. And for any changes to these things, just a simple majority will do the work. And another example would be Article 240, which allows the president in a few situations to make legislations with just a stroke of pen. And there's no need for an approval from parliament or state legislatures, and all of these are considered as an amendment to the constitution. So from all of this, it is obvious that the amending power and legislative power flows from the same body, that is the parliament. The different majority, as argued by the petitioners, is merely procedural. So, from all of this, it is obvious that the amending power and legislative power flows from the same body, the parliament, and it's just a different type of approval for an amendment to the constitution. So, the amendment was very much valid. The state also argued that the procedure described in this article doesn't mean that the parliament's powers are to be exercised by a fluctuating body of varying majority and not by the parliament. On the other aspect, the state argued that the amendment doesn't fall under the definition of law under Article 13 because the law mentioned in Article 13 means just an ordinary legislation like Indian Contracts Act or the Penal Code or the Stamps Act. And since this is a constitutional amendment, Article 13 won't apply here, as Article 31A and 31B are not legislative in character. On this issue, the Supreme Court, while rejecting this lengthy argument of the petitioners, held that the requirement of a different type of majority is merely procedural, and this can by itself be no reason for entrusting the amending power to a different body, and a perusal of Article 368 confirms this view. The final argument by the petitioners was, since the subject of land is in List 2 in Schedule 7, which is the state list, and states alone have the power to deal with any issues relating to land, be it laws, policies, orders, or anything. But here, the provisional parliament has encroached on the state's exclusive power by changing property rights through Article 31. Now, Parliament could not validate a law which it does not even have the power to enact. So, the provisional parliament could not insert land legislations in Schedule 9. because that would be encroaching on the state's exclusive power. And Articles 31A and 31B, despite being provisions of the Constitution, they are legislative in character. The provisional parliament exceeded its power to amend the Constitution by inserting these legislations in Schedule 9. So, for this reason, this amendment must be declared unconstitutional. Rejecting this argument, the Supreme Court held that the amendment just seeks to insulate a few laws from judicial interference, and it doesn't interfere with the regulation of land in any which way. And this amendment is not some law or a policy or any regulation on land, but just an amendment to the Constitution. So, it is the Parliament alone which is empowered to pass an amendment of this nature. And this amendment in no way affects the matters on state list. This argument only holds good when the Parliament validates a law which the state passes without no power to pass such law. So finally, after these lengthy battles in the Supreme Court, the first ever constitutional bench upheld the First Amendment to the Constitution, and the states were allowed to acquire lands of the Zamindars. In all the states, the government had actually assigned all the acquired lands to the farmers, and the zamindars were left with just a handful of lands. Here, one thing I didn't understand is that why did the president pass the Constitution Removal of Difficulties Order number 2? Because Article 379 already empowered the provisional parliament to perform all the tasks of the parliament as if it were a parliament. So, share your thoughts on why the president passed this order on the comment section of this same episode on our YouTube channel Hamlet of Law. Also, zamindars were put to a huge loss after the mandatory acquisition because, contrary to the popular belief, zamindars were not just given lands out of thin air. They had a lot of duties and liabilities by virtue of them being an owner to all of these lands. For example, the British would just take away the lands from the zamindars if they failed to pay them the yearly tax, and would very easily replace these old zamindars with another person who promises to pay the same or more tax. So imagine the government just barges in and takes over Reliance or Tata or Adani Group in its entirety and give no compensation to the shareholders. The acquisition of Zamindari lands was somewhat similar to this. On the other hand, the government had to do it. It had no other option. Suppose if in an area, a handful of people own all the water available, and if they refuse to share this water with anyone unless they comply to their terms or pay them some money, the government has to take care of it, and government has to take control of it and do something about it. So, in this case, there was no other option for the government to do it. At the same time, the government couldn't afford to compensate for all the lands it acquired, so there was no middle ground to reach to. The government acquired all of these lands without compensating the owners. Also, the government could have just waited until the full parliament was formed, especially on the issue of Zamindari abolition laws. And I somewhat agree that the government needed to restrict free speech to maintain public order, but on the Zamindari abolition and reservation front, the government could have simply waited. Because it was not like if the Congress doesn't do it, no one would do it. The major contender to the Congress party, the Communist Party of India, was even more extreme on these issues of reservation and abolition of Zamindari system. So I feel the amendment wasn't just about providing way for social progress and to maintain public order. There has been an element of appeasing the citizens to get votes. Now, the ratio on provisional parliament and its powers did not again come into question because the full parliament was formed immediately in the next year, in 1952. But the ratio in the three rulings in this case, the first one was that law as mentioned in Article 13 doesn't include constitutional amendment, so the parliament is free to amend all parts of the constitution. The second one being fundamental rights can be amended absolutely. And finally the third one, that full protection can be granted to laws inserted in Schedule 9. So all these three aspects were overruled and upheld in different cases. The first issue that law in Article 13 doesn't include constitution amendment was rejected in the famous Golaknath case, and that case held that law in Article 13 also includes an amendment to the constitution, so the parliament can't amend fundamental rights. But again in Kesavananda Bharati case, the court reversed Golaknath's ratio and upheld Shankari Prasad's ruling that law in Article 13 doesn't include constitutional law, so it doesn't come in the way of Article 368 power in any way. But the Kesavananda Bharati case also introduced something called the basic structure of the constitution and held that the parliament can't change this basic structure of the constitution at any cost, but The case didn't define what exactly the basic structure is, but it just gave a few examples like federalism, democracy, and independence of judiciary, and so on and on. So the Kesavananda case accorded the tag of basic features to a few provisions in the constitution and then held that the parliament can amend the constitution including the fundamental rights, but if these fundamental rights happen to be a part of the basic structure of the constitution, that amendment to that extent would be invalid. So this interpretation that law in Article 13 doesn't include an amendment to the constitution holds the ground as on today. On the Schedule 9 aspect, the court suggested the level of protection and validity of this Schedule 9 in a series of judgments. But in IR Coelho case, the Supreme Court held that laws can be placed in Schedule 9. And by virtue of this, all these laws will gain certain protection granted to this schedule. But if these laws violate the basic features of the Constitution, the courts can't exercise their judicial review and the courts can't nullify these laws. It doesn't matter whether these laws were inserted in Schedule 9 because the basic features of the Constitution reign supreme. So, as of now, not all fundamental rights are basic features of the Constitution, but just a handful of them. So, laws inserted in Schedule 9 can still be valid if they violate certain fundamental rights, not all of them. So, this is the First Amendment to the Constitution and the Supreme Court's decision on it. And this Shankari Prasad case is a case that sparked off the debate on the amending power of the Constitution, which ultimately ended with the basic structure theory in the Kesavananda Bharati case. There'll be a lot of future episodes discussing the Sajjan Singh case, where the amending power was again challenged, and then there's Golaknath case, there's Kesavananda Bharati case, there's Minerva Mills case, and a whole lot of other cases. So stay tuned to Hamlet of Law. The PDF version of this episode will be found on www.thelawreporter.in. This is your host Naren Rudra, signing off.